Right, order. On behalf of the committee, can I express a very warm welcome to the first of our two panels this morning, and if I could introduce Chris Desira, solicitor from Seraphis, Barbara Drozdovich from the Eastern European Resource Centre, Kuba Jabłonowski from the 3 Million, and Luke Piper, solicitor and legal advisor to the 3 Million. You are all very welcome. As I said, we have two panels today. We have lots of questions to ask. Do not feel under an obligation, all four of you, to answer all of the questions. And if you could keep your replies as succinct as possible, that would help us to get through all of the issues that we want to raise. Can I begin by asking you about the number of applications that have been made under the settled status scheme? Now, it's quite a large number now, and the results have split between settled status and pre-settled status. First of all, are you aware of anyone who's been told no? Anyone refused? Anyone?
No.
No, fine. Okay. Secondly, what do you understand other outcomes means? Now, there's a definition from the Home Office, and I just wanted to check that squares with your understanding. It says other outcomes includes other outcomes that did not result in a grant of leave because the application was withdrawn, okay, was invalid because it did not include the required proof of identity, or void because the applicant was ineligible to apply, for example, because they were a British citizen. Well, I can't quite understand why a British citizen would want to apply for settled status, but hey. So are you aware of anything that gives you cause for concern in the other outcome category?
From our point of view, East European Resource Centre, we provide services to people to vulnerable users of the settled scheme. Is the withdrawal of applications, because there seems to be quite a significant number of people who, especially those whom in Home Office definition are vulnerable, so will struggle in accessing the scheme or accessing the process of sort of applying altogether. There is quite high proportion of withdrawal of applications if people are not supported to do so. One of the reasons that we find is the fact that, as you are aware, the application is based first on kind of like automated check of the records held by Revenue and Customs and Department of Work and Pensions of transfers, either in and out, so to speak. If people don't have those transfers or they are not visible in the last 5 years, there is a quite high tendency to kind of run away from the scheme. And that requires support and encouragement for people to do so. There is also the issue that people might not want to take up the application again once it is left behind, and this is something that is happening in communities, as I say, among the vulnerable adults, but not only, quite frankly, because we are aware that there is still quite high skepticism as to whether people should need to apply to the scheme altogether. So this is why that encourages people to disengage from it at the stage of application.
Do you mean principled objection?
Or some according to our sort of work, and it's based on 650 interactions with users, so it is some number. People are waiting to see what is going to happen with BrExit. And there is some group of principal objectors, but basically there is growing sense of disbelief that BrExit would happen altogether.
On the applications being rejected as invalid, that would slightly concern me, because the Home Office are meant to have an approach, and it's in their guidance, to help applicants through the process where they're missing information. They're meant to engage with the applicant to make sure that the applicant provides the information. So there really shouldn't be that many high invalidities. Also, there has not been any refusals, but what the statistics doesn't tell us is how many people were granted pre-settled status when they should have been granted settled status. And the Home Office are not treating the refusal of settled status as an immigration decision. So no one's being refused settled status. They're simply being told you're getting pre-settled status instead. So they can't challenge the settled status.
And that's because of a difference of view about whether they've demonstrated a 5 years residence.
Well, it will be on a residence
would principally be the reason.
Yeah, it would be, but then we'll delve into a lot of problems that are associated with residence and the checks and what data is held by the Home Office and what can be accessed by the applicant. But it's usually based on the residence. And the way the Home Office are treating this, it dictates how their stats are published, because their stats will then say no one's been refused, rather than saying X amount of people have been refused settled status, but they've been granted pre-settled status.
Which brings me neatly on to my next question, is what further statistics would you want to see the Home Office publishing?
Well, ideally would want to know how many have been refused settled status and then granted pre-settled status, and why they were refused settled status. In terms of engagement, public engagement, to know how many people are applying and where they're applying from, would want to know locations of people applying, so we'll know where the black spots are, where people are not engaged with the services or not. I'd also want to know how many people are going through the funded organisations that receive funding from the Home Office, so how many are applying through them and how many are being granted through them as well. The stats that we have right now are not enough, so the Home Office is producing monthly stats, and so we have 2 sets of monthly stats at the moment, which just tell us how many have applied by nationality, but they don't tell us how many non-European citizens are applying and what nationalities. So we also have a problem with engagement with those communities, because we don't know who they are and where they are. There will be quarterly reports. The Home Office intends to produce quarterly reports. The first one will be in August, but they haven't told us what will be in those quarterly reports yet.
But just looking at the 668,000 applications concluded, basically 2/3, 1/3 settled, pre-settled, has that worked better than you feared, or
I think
worse than you hoped?
We were pondering about this question, whether is it good or is it bad information, and what is, I think, quite important is to look at when exactly those applications fall, in what periods when they fall onto, because the highest number of those close to 700,000 applications, I think they were made in around March, so when people were expecting that there might be the 29th March deadline might be met. And also the application scheme, the scheme started as well openly, fully around that time. And when you look at the data, for example, for Polish nationals, who are kind of particularly badly represented among applicants, comparing to the general proportion of them within European community in UK, then these numbers kind of they shrink, they fizzle out, which worries me that it means that there was some momentum around March, April time, and that momentum we are losing. So it is difficult to say whether we looked at the peak of applications or that was just early start of something that there has a promise.
But that's, excuse me interrupting, but that is a point about encouraging others to apply.
Yes, so
it's not an observation on how the system has worked for those who have applied. Because I'm just trying to understand it, because there's a lot of concern. But for those who have, they would say, "Yeah, I got it and it worked okay."
Yeah.
Would that be a fair comment for those who've applied and been granted?
Well, I'll take the first point about the 700,000 figure first. The problem we have with this figure is that we don't know what the total figure is.
Yeah.
So our firm is also contracted by the European Commission Representation Office in London here, and we've been working with them and the embassies for a year and a half or so. And the embassies have tried to figure out the true number of their citizens living here in the UK, and they're unable to do that because some have a mandatory registration process, some don't, and even with a mandatory registration process, not everyone registers when they're in the UK. What they do say is that based on the ONS statistics, the figures are quite low, and they estimate it that it will be between 40 to 50% more than the ONS statistics. Plus, then you have family members on top of that. So when we talk about the 3 million, you're actually thinking more closely in line between 6 to 7 million, possibly, when you include family members. So the figure doesn't tell us what the ultimate total is.
I accept that entirely. My point was simply trying to understand how it's worked for those who have applied.
You'll have varying feedback. So you'll have one end of the spectrum where someone has said it's been perfect. You know, the app works, the application worked, I got my status back within a day. Yeah. Then you've got the varying end of the scale where someone's applied over a month ago and they still don't have a decision. And this is where the statistics show us that there is a delay now of at least a month between the statistics that have been published from April to May now on the number of applications.
So more statistics of the type you've just described in answering my question would help us to get a better picture.
Absolutely. So dates of application, if it's still outstanding, how long it's been outstanding for and why.
Okay, very helpful. Mr. Piper.
Yes, I think to answer your point in terms of experience, I'll come to in a moment, and my colleague here will speak more clearly as to the issues surrounding measures. I think it's all fine for the Home Office to produce numbers of applicants, but ultimately we don't have the full picture. Indeed, we don't know the numbers, and that's the point that Mr. Desiree has made there. But I think what's quite key in all of this is that we don't actually know what the performance indicators are that the Home Office are working to. Okay. And I think that's a really key point to take from this. And indeed, we have come up with some resistance in terms of actually getting that insight and getting that information. I think so. It's not just the data itself, it's also what are the Home Office measuring this against and how are they measuring this against. So, for example, we've got quite key concerns about how they are identifying the types of people who are applying. Yes, they're going to get insight into nationality, national insurance numbers and things like that, but other things like certain other demographic issues will not actually be identified, particularly around disability and such. So we've got quite key concerns about that as well. And in terms of your point about experience, as a practitioner who has helped a number of people with the application process, I think those that get the assistance and get the help will generally have a positive experience. Yes, there will be delays. I have a colleague who was on the phone yesterday for half an hour with the EU settlement team. Very lovely people, but still trying to struggle and get through this point, and there's delays and such. But I think really the questions that we need to be looking at is the wider engagement problems. How do we reach out to these people who aren't going to apply and so forth? And I think that's really the biggest challenge in this. And not to mention the elephant in the room about this whole EU settlement scheme is that the mandatory nature of it and the consequences of having to go through it. And I must stress that is avoidable. There is a way that we can mitigate the problems that would lead to.
Well, no doubt. I suspect we'll return to that. Just one other question for me before I bring colleagues in, and this is about entitlement to benefits. Because there are, I know of one case myself, of someone who is an EU national, lived in the country for 10 years, but has been told, for the purposes of applying for universal credit, that she is not habitually resident. Now, I asked the Work and Pensions Secretary yesterday, does the grant of settled status mean automatically that the person who's given that settled status is regarded as habitually resident for the purposes of applying for and receiving universal credit? And the answer I got was, yes, that's broadly true, but I wanted to ask you, since you're sitting here, do you think that is broadly true? And do you think the DWP understands if they are being presented with people who've got their settled status, that means they can't argue on grounds of habitual residence?
It's broadly confusing.
Broadly confusing, right, okay.
I think it's a large part, I'm kind of saying a large part of our work is effectively the fighting cases in welfare sort of corner of the system. So with some applications, strangely, people who are granted settled status, these applications settled status is being effectively seen as indefinite leave to remain, therefore, in a way proving that you have to be treated like British citizen for all kind of purposes in terms of welfare. In other cases, not. And there is also additional, in terms of EU nationals, they have to meet the treaty rights, so have to be qualified persons to access certain benefits, not all of them. It's, again, confusing what sits where. And that is not consistent, we believe, in a way how settled status is being treated as evidence of status for purposes of housing allocations and benefits, and that includes also pre-settled status documentation or other sort of decisions, where this is why it's significant number of vulnerable, disadvantaged people, such as, for example, the homeless people. There is a risk that people will be seeking all sorts of avenues to satisfy the evidence for settled status, the full one, so to speak, because it is believed that pre-settled status is not helping them in anything. Now, it is confusing, and we have asked for some sort of collaboration with WP so that at least we can understand what is their point of view, not even mentioning influencing it, but it hasn't gone far.
I would say on the benefit side of it, so broadly they'll have to meet two steps. One of them is the habitual residence test, and then confirm that there is someone who's eligible for the benefits. The second part of it doesn't discriminate on nationality. So the first part of the test is where we talk about settled status and pre-settled status. If they have settled status, they should pass that test automatically. If they have pre-settled status, then we're talking about whether they're exercising treaty rights or not, and whether they're lawfully resident or not. So, and the DWP has issued guidance on this, titled Memo ADM 09/19, which confirms this. But the problem we have is it's a communications issue, because the Home Office are not necessarily talking to DWP, and the top of DWP are not necessarily disseminating this information to the casework on the ground. And this is where you get the inconsistent decision-making.
So there is an issue here?
Yeah.
Right. Now, Joanna Cherry. Thank you very much.
I just want to come in briefly there on the Chair's question. Earlier you said that the problem is that although there's been no refusals, the statistics don't tell us how many people have applied for settled status but just got pre-settled status. Isn't there a risk that those who might have been entitled to, probably should have been entitled to settled status but have only got pre-settled status, will then come up against the habitual residency problem when they go to try and claim benefits? Yeah,
I mean, absolutely. The benefits are one part of it, but also having a secure status is another, and not having to engage with this system again a second time around. So, this predominantly affects the more vulnerable and women and children more now, because they're the ones that may have less evidence of their residence. And it's also a public law policy issue here, because people may be applying for this and failing the residence checks, but they don't know why they're failing the residence checks, because we don't have the data behind that. So they could be failing the residence checks because they can't provide one piece of evidence, but they think they need to provide 7 pieces of evidence.
Yeah.
And the difference between 1 document and 7 documents are crucial for those at the very bottom of the scale. And those at the very bottom of the scale are the ones that need to access benefits most.
Great, thanks. I want to just move a little bit on from what we're talking about at the moment to the fact that we've chosen to have a constitutive, the British government have chosen to have a constitutive rather than a declaratory scheme. And earlier, one of you said it's the mandatory nature of the scheme that's the problem. And I think you said that, Mr. Piper, that there might be that aspects of that might be avoidable. So I want to look at what happens when we get to the actual deadline. Say that, on the assumption on the assumption that there's a withdrawal agreement, which I realise is a pretty shaky assumption at the moment. But let's just assume that people come to their senses, and there is either no Brexit, which I think would be the most sensible outcome, or at least some kind of a withdrawal agreement. In that situation, if the scheme comes in, there's going to be an end date after which people cannot apply. And we've all heard that there's been worries that some people are unaware of it and will miss this deadline. Do you have any clarity on what will happen to people who miss the deadline or try to apply after the deadline?
So, if I may, there's 2 points to be made quite clear of there. You say that people will not be able to apply after the date. That will not be the case. People will still be able to apply, but it's my understanding that the Home Office will be adopting an approach where they will be expecting people to have good reason for applying after the deadline. The government's position on the consequences is not very transparent, I'd have to say, and you will have heard before, and I've spoken on about the Home Affairs Select Committee making this exact point, that the consequences are that those people who do not apply, do not have the status after the particular date, will not have a lawful basis in which to be in the UK. And the realms and the consequences of that ultimately come down to the hostile environment and the effects that are felt by that. So not being able to work, claim benefits, housing, lack of access to NHS and so forth. So it's quite serious.
I mean, do you think having a declaratory scheme would get round that problem? Because some government ministers, when asked about this, have suggested that a purely declaratory scheme also risks causing confusion with people being undocumented and ending up like the Windrush generation. What would you say in response to that?
I think that's perhaps misrepresenting the declaratory approach, and indeed I believe that in a recent session in the House of Commons, Stuart MacDonald made this exact point, is that ultimately, yes, if there is this baseline of a declaration, a legal declaration that people fall within a certain category, they have that legal safety net on which they can rely. But ultimately, yes, people will need to register, not necessarily apply for status, but they will have that baseline of security that they can rely on, and then have the opportunity to then be able to acquire a document to represent the status that they have in law.
I would echo what Lucas said. But also, when we've asked the Home Office on this question, their line is a person will not have a lawful residence beyond the deadline if they don't apply. So that's the official line. And while they can apply late, as Luke said, they need to have a good reason. And good reason isn't going to be because I forgot and I missed the deadline. If you look at good reasons in other immigration categories, you need to have fairly good reasons. And I'm talking about an example that you're in hospital and you were comatose and you were incapable of completing the application yourself, and also you've got the medical evidence to prove what you're saying is true. So that's the kind of extent of levels of good reason that you'll need. And there'll be a two-stage approach then at that point. That person will need to have a good reason, and the Home Office will need to accept it's a good reason before they even go on to consider the application itself. So, and during that window, they're unlawfully resident. So they could actually fall on the first hurdle. The Home Office could say you have no good reason, therefore we're not even considering your settled status or pre-settled status application.
So in that situation, you could have, in theory, somebody who in reality and on paper qualifies for settled status because they've been resident in the UK for many years, but is unable to apply because they've missed the deadline and the Home Office decides that they've not had good reason.
Yeah, absolutely. Yeah.
Barbara, you want
There is also the reason why people will struggle with applications that is very pragmatic, quite frankly, and has nothing to do with people not wanting to do it or being comatose. Obviously, these are very serious issues. Obviously, and we are looking at, for example, older people with dementia. Someone has to do for them. Lots of them will be forgotten, so to speak, and so there is quite a big group of those cases that will not meet the deadline. But I'm thinking about the simple fact that you have to have the certain ID documents to be able to apply. Now, to get a passport or in certain EU countries, you have to have ID card. The ID card cannot be issued outside of the country, so you cannot pick it up in the consulate. But even if you could, you still have to go back and apply. So quite frankly, it might take up to 6 months or more for individual to acquire documents to even be able to put in application. When we are looking at and it's involved with costs because it might be travel, it might be having to stay in the country, so living work. For example, a month waiting for the document to be issued back in the homeland. Now, if we are looking at single individual, it's maybe not that drastic, but if we are looking at the family, the situation is kind of getting more and more complicated. The cost and the stress around the kind of trying to meet the deadline will be quite significant, and there will be this pragmatic issue of documents. We know that many consulates have sort of beefed up their consular sort of services, like workforce side of things, to help people with applying for documents, reissuing passports. But that it will not be sufficient still, especially in more remote areas, in villages, in small towns where the distance to consular services might be significant. Again, that's linked with cost. Therefore, this deadline is looming, and it's way too near to us for us to be able to say collectively as the society to secure access to the scheme for everyone within the deadline. The deadline, we believe, has to be moved regardless of the date of actual Brexit, which has moved already, even though the deadline hasn't.
I mean, Barbara has raised an important point here about whether the question about a declaratory system, or if not, have a system where you still have to have a mandatory application process, but exclude anyone eligible under this from the hostile environment rules. Because identity documents are going to be one of the biggest problems. And the time frames to get documents from all of the embassies are increasing. And if you never had a document in the first place and they need to investigate your nationality, you could be looking at upwards of a year or more to get a document from them. And so, again, when we move to the very vulnerable end of the scale of the people that need to apply, they normally apply when they have to, when it's necessary, near the end of the deadline. And only then they're going to realise I don't have an identity document. And only then they may either have an ineligible application because they can't prove their identity, or they're going to have that big window of unlawful residence until such time they get that identity document, and then they can apply late at that point, maybe 6 months to a year later after the deadline.
Can I ask you about remedies for people who are refused settled status? Because in Article 18(1)(r) of the Withdrawal Agreement, what's been agreed is that applicants shall have access to judicial and administrative redress procedures in the host state against any decision refusing to grant the residence status, and that the redress procedures shall allow for an examination of the legality of the decision as well as of the facts and circumstances on which the proposed decision is based. Now, as the government's proposals, the British government's proposals stand, what options are available to an EU citizen who wishes to challenge a decision refusing to grant him or her residence status? And how does that compare with what I've just read out, which promises judicial and administrative review on legality and facts and circumstances? Perhaps, Mr. Piper, you'd like to start on that one.
Yes, gladly, yes. I think ultimately the system we have at the moment does facilitate a right of appeal process to a decision relating to the European regulation. So that's in respects of rights that are being exercised now. There has been some complications, shall we say, in relation to other family members and rights of appeal, which have now been resolved thanks to the intervention of the European Court of Justice. But ultimately, there is a process at the moment that does facilitate a finding of fact function, but that is in respects of decisions made under EU law as it stands at present. As far as it goes in terms of decisions made under the EU settlement scheme, there is no right of appeal as such to a court, to a tribunal. There would be if the decision was made under regulations, but not under the EU settlement scheme. There is an administrative review, but we understand that the government is intending, if there is a deal, under the terms that are set out, but you've just read out there, that the government does intend to create a right of appeal to decisions made under the EU settlement scheme that a person can exercise in tribunal. We have yet to see details of that, and yes, it's not clear when that would arise.
I suppose it's important for non-lawyers to understand that there's a big difference between an administrative review followed by what's called judicial review and an appeal on facts and circumstances, because the judicial review can only look at the legality of the decision. Have proper procedures been followed? Have the rules of natural justice been applied? Whereas a judicial review before a proper tribunal can actually look at the facts and circumstances and can actually pick through the evidence that the applicant submitted that they were entitled to settle
Absolutely,
status.
and indeed that point has been laboured recently in the European Court of Justice and indeed the Upper Tribunal, which are two very senior court structures that we must adhere to. And indeed, judicial review is not an effective remedy, arguably, as you have referred to there. But I think let's be very clear about something. Administrative review, for the purposes of those who are not lawyers, administrative review is the internal reviewing function of the Home Office, whereas a appeal in a tribunal is an independent tribunal reviewing the facts of the decision-making process.
And I mean, if we look at the statistics for current immigration appeals, the Home Office loses them in the majority of cases, don't they?
Yes.
So when
they withdraw their decisions before we get the opportunity.
When decisions are reviewed by a tribunal, looking at the facts and circumstances, the Home Office usually loses or withdraws. So we can see how powerful a review in facts and circumstances is.
Absolutely, and I worry because historically there has been a culture of eroding of appeal rights by the Home Office through amendments to the statutory functions that govern the appeals process. And I worry that if there is no deal, that there will be no right of appeal. I think that's pretty clear. I'm sure Chris can confirm that for me. And the only redress following an administrative review would be through judicial review, which is not. It is an expensive remedy.
Whereas if there is a deal, the British government will be bound to introduce a review in facts and circumstances because that's what it's signed up to in Article 18.1R. I'll just ask you very quickly, Mr. Desirad, is the UK's position on these appeal rights in the event of no deal a concern for the Commission and EU ambassadors?
Yes, I mean this is one of many key points for them, that in a no-deal scenario there's no appeal rights at all, and this is something that needs to change. I would say that even with an appeal rights, there's still deficiencies in having an appeal anyway, because the way the residence checks work, and a person on appeal will not have access to the data behind the automated residence checks because the Home Office don't disclose that data. So even on appeal, they won't know where the gaps in their residence appear and what evidence they could have proved to plug that. And in cases where we've made a subject access request from the Home Office to get that information, they either say we don't have it or we're not providing it because you fall under the Immigration Exemption on the Data Protection Act that says that it may affect our ability to police our borders if we disclose this data to you. So even in the appeal system, we may have problems appealing anyway. I would also say there's the practical and issues as well if you don't have an appeals process, because, again, all of those people at the very vulnerable end of the scale will not be able to access legal assistance to do an administrative review, which has deficiencies anyway, because you can't administratively review, for example, an application that's invalid. And also they can't afford to get a lawyer to represent them through judicial review process, which is immensely long and expensive. So we have that issue as well on that side.
That's very helpful. Thank you. It's just we need to move on because there's still lots of ground to cover. Jonathan Ginodley.
We have already touched on awareness of the scheme and government support, but I'd just like to go back to that in a bit more detail, if we may. When the ICIBI, the Independent Chief Inspector of Borders and Immigration, asked the Home Office about possible pressure on resources of the SRC, it found that senior managers, and I quote, recognised that there was a link between demand on the SRC and effectiveness of the Home Office's communications about the scheme and the quality of its published guidance. So I suppose my question is, what are your views on the accessibility and effectiveness of the support provided by the SRC? And let me extend that to assisted digital support and the ID document scanning locations. And let's start with the basic question of, in your experience, do people know that these services exist?
I have to admit that I'm quite critical about the way how awareness is being raised about the scheme in the first place. What information is being available for people as a kind of general and generic information about the scheme, and whether that's accessible or not. So there is a guidance kind of guiding people through the application itself in 23 languages plus Welsh, available on Home Office website, which is obviously accessible to a questionable level on its own when it comes to certain vulnerability groups. But there is not really comprehensive information that is easy language, sort of easy read document for people to really understand the bits and bobs about the application, about the scheme itself. There is a list of issues that we think that are not being explicitly explained to people. One of them is, for example, where the evidence is coming from. So when people do see that when they see that Revenue and Customs, DWP don't see them because they never worked, for example, like stay-at-home mums, they tend to withdraw instead of have access to information that actually there is a number of other ways of providing this information. This information has to be accessible for people, not written in legal language that is difficult to get through for advisors even. Other issues are, for example, third country nationals, members of families who are pretty poorly treated in terms of access to information, issues about criminal record and how it's being treated, and it doesn't mean that people will be immediately deported from the country if they disclose it, and so on and so forth. There's eight at least areas that we have identified that are not being explained. Now, this is on the side of general awareness raising thing. There is also the instruments that you have kindly mentioned. So, for example, the Home Office own resolution center that is really not an advice and information helpline. It is the resolution center for pending applications. That service does not speak, it speaks English only. So, and there is really we don't understand why it is the case, because just by making sure that Resolution Center has language line will encourage people to engage with their concerns about their pending applications, then or to correct errors in submitted applications, because for some reason there is no step back option in application process. So you have to submit erroneous application if you kind of realize that you made something wrong. Just the sheer fact that you cannot speak English, you cannot ask for Polish or whatever French translation is very strong deterrent from using the service. So applications are not being completed, or the decisions are being wrong, but not based on the actual facts. And finally, the digital assisted service, which is a mechanism supporting people with IT literacy issues, again, is only in English. Therefore, it's really not accessible for lots of users who will struggle with English, be it because of their low level of this language, or be it of age, of early onset of dementia, for example, that has impact on the way how we operate in languages and so on and so forth. So that's not really very accessible either. And with funding that the Home Office has provided for supporting vulnerable users in accessing the scheme, so the 9 million funding for the settled sets grant funding, that was distributed to overall 57 lead organizations that themselves might or might not have some delivery networks, but that's not yet published. What is exactly the structure and who delivers what and where. There seems to be quite high onus on those organizations to provide a high level of this awareness-raising activities, and this is not what organizations should be doing. They should be doing outreach. They should be reaching to people who are missed by communication. So there is no capacity. I don't believe there is capacity as we are now.
Yeah. On awareness, I would say I've travelled to over 100 locations across the UK and met dozens of different types of communities, including non-European communities affected by this. And the huge majority of them have no awareness of the grant-funded organisations, the Settlement Resolution Centre, or the Assisted Digital Service. In some cases, and in actually quite a lot of cases, they don't even have an awareness of the basics of the settlement scheme, or even an awareness of the settlement scheme itself, or even have an understanding, especially from the non-European dual citizens, have an understanding that BrExit is going to affect their residence status.
Could you quantify this in any way? I mean, what sort of proportion of people are we talking about here?
It's really hard because I'm just based on
Yes.
my own experience. But the biggest concerns for me on that knowledge base are those that are non-continental Europeans. So those from East Timor who are also Portuguese, or those Sudanese who are also French, or those Somali who are also Dutch. So they have their passports because of the way they've reached Europe and travelled through Europe. But all they have is a basic understanding that a passport grants them rights, but they lack that understanding of what those rights are and the Free Movement Directive and what Brexit means. On the Settlement Resolution Centre, I met... Yeah, sorry.
What should be done to remedy it?
It's all Home Office communications. This is all Home Office comms.
Home Office communications.
So the Home Office...
And language, which is the point.
Precisely. So the Home Office had a communications campaign between March and May, and it's ended now. And we have no idea from them what their next stage of the communications will be. And all of the communications that they have are in English, but some are translated, but poorly. Even with, and this is even with embassy assistance. So when they do translate documents, they have a private company that translates them. And the translations that have occurred have been checked by all of the embassies. The embassies fed back their information with the translations, and they still made errors on the translations. So even when they're translating the European languages, there's a problem, let alone when you start talking about Arabic, Somali, and so on. So the comms have issues, and the comms are not reaching these communities. And the communications are not clear enough anyway, because they don't talk about it being a mandatory scheme, that there's a deadline that you must apply, otherwise you will be unlawful. And they also don't talk about family members of European citizens or EEA nationals. And the comms will definitely not be translated in non-European languages. So my concern is always at that end of the language scale.
And just to add to that, in terms of the delegating responsibility for outreach to the 57 grant-funded organisations, there seems to be the trend that the Home Office tries to say that it is the responsibility. There is now grant funding in place, and those 57 organisations have to go out and reach those communities. But there are concerns in terms of the reach within the UK. So obviously there is quite a lot of concentration in London. The Home Office to date released only a heat map indicating how many organizations cover each region, but we don't know where exactly they operate. So there is quite a lot of fear that some regions of the UK will effectively be deserts without any outreach or very little outreach activity. And we're talking here about areas in the southwest, for example. Just because somebody covers Bristol and Swindon doesn't mean that they'll be able to reach out to Cornwall or Truro or Exeter.
The funded organisations don't, although they cover the whole of the United Kingdom, it's about how many organisations in each area. And Northern Ireland is a massive problem, and Wales is a massive problem. Not only there's not that many organisations there anyway, there's maybe one or two covering the whole of those countries. And knowledge, especially in Northern Ireland, is very sparse on this.
Just finally, so what are the implications of this problem? I mean, if we don't get it right, what's going to happen as a result?
It needs to be said that there is very high risk that there will be some repetition of problems experienced by the generation, obviously at some point. I will use that term, simply because there is not enough information. And I will highlight that there is difference between communications, comms, and outreach. Comms is something that you access and you read about it. Outreach is for specifically those people who are not accessing communications because they can't. And so we have to make sure that both ends are delivered. But if people don't even know that there is link between Brexit, which I think in some areas, in some pockets of disadvantage might be as high as 50% of population, don't see the link between their immigration situation and Brexit, or don't even know that Brexit is actually happening, that it has something to do with them at all, well, you can't really expect that it will apply. So if they don't apply, they might fall into a hostile environment, and that might happen very quickly.
Okay, we are going to have to crack on because we've got lots of other colleagues and we have got a second panel. So my apologies. John Whittingdale.
I have just a quick question. You talked about the embassies assisting with the translation to make sure that the language is correct, and Barbara talked about obviously embassies having a role if identity documents need to be produced. But I wonder if embassies aren't or shouldn't be taking a more proactive role. I mean, they have a pretty good relationship in some cases with citizens in this country, and they also can provide information. And since there appears to be a problem in getting information and help, can you give any examples of where embassies are actually taking an active role and of setting a good example to others?
Yeah, so the European Commission Office has been taking points on this since November 2016. And since then, they and all of the embassies, including the EEA countries, have been meeting every month to discuss what they want out of the settlement scheme and how they can reach the most vulnerable. And since January 2017, they have been meeting with the Home Office monthly on this, raising their concerns every month with the Home Office on what they can do, and also raising their concerns about the communications. As well as those monthly meetings, they're also having public seminars with citizens, so they're doing outreach work all of the time. And this is where I talk about having met all of these groups of communities in various areas across the United Kingdom, because they have these outreach information sessions where they try and reach people to attend these sessions so we can educate them on how to apply and what to do. As well as that, they're trying to push the Home Office to ensure that these communications, their communication campaigns are ramped up now. Because the problem is getting the message out now, not 4 months before the deadline, because a lot of work needs to be done on gathering evidence at this point, especially identity documents. But the Commission's view is that we'll do what we can, but the communications of the scheme is the responsibility of the Home Office. But even then, with all of that work that's going on, we're only reaching the people that have an awareness of what's going on and have the time and space to come out and attend one of these sessions. We're not reaching any of those we consider on the vulnerable list, and we've created a list of vulnerable groups, and this list contains over 20 categories of vulnerable groups, and I have it here, I can read it out to you. We're worried about not ever engaging or reaching those people because they're not the ones that are well connected or well knowledge on this scheme or have issues with them that they can't engage with this as well. And some of them, however good the Home Office communication campaigns have been, and to be fair, the Home Office have been doing a lot of work on communications. They're not doing enough, and they're not targeting communications campaigns on air, in media which will be accessible like from these groups, like television, for example.
I do understand that your concern about people who are going to have greater difficulty in obtaining information for one reason or another. Yeah. I just wondered whether there was any particular country whose embassy is sort of doing much more in making an active effort to get out there, find people, to make sure that they understand.
Yeah, they are do. So they range from very active to not so active. Very active are those countries like Spain or Portugal who have been doing outreach work a lot, and also taking mobile units to go to places as far as Northern Ireland to redocument their citizens, and as well as having employed people within their embassies to deal with casework as well. So they're applying on behalf of people to make these applications. So there's a huge effort on their part, but the trouble is they also have the restrictions of resources as well. So these embassies have sometimes as few as 10 staff in them, and they don't have the resources to do everything that they want to do.
Okay. Thank you very much. Hal Williams.
Thank you. Good morning. I have a particular concern about people who would find it difficult to use the assisted digital service, either because they just literally have no access to computers or whatever, or in areas such as my own where the infrastructure for digital work is so bad that it practically renders it useless. Do you share those sorts of concerns? Do you have any observations?
Yeah, I think we do. One point that kind of I think we do need to, and this is something that we've not really touched on, reaching out, accessing and assisting those with disabilities. And I think there is a very quick move from the government to say we have a digital assist service, go to that. But there's been a lot of issues raised with me and the organisation about comms and so forth to those who are, say, blind, deaf and and so forth. So there are some serious issues around that. And those extend to also issues surrounding the ability to use technology, use the scheme, even understand what it is that they need to do to be able to apply. So I think, yes, I would share those concerns.
And just to add, there are two types of concerns really related to the system being digital only. So one is for the end user, but the secondary concern is for support organizations. So there is currently no functionality to preview the application. There is no functionality to actually track changes to the application procedure. So something may be true one day and then change another in terms of how the application form works. So for example, we had that issue of the application form collecting national insurance numbers from people who hold permanent residency cards, which it shouldn't run automated checks. We flagged it up in our report to the ICBI, which was 2 weeks ago, and in the meantime, as of last Friday, that check was no longer in place, so the inputting national insurance number is optional. So it not only impedes the ability of people to apply, but also impedes the ability of monitoring organizations to know what exactly is going on.
And obviously, application is one thing and the easiest one, but obviously people have to live with online product. This is what really seriously worries us because it has already been shown to be a problem. So the fact that the settled status cannot be evidenced by either a letter, the decision letter, the people do receive confirmation of application being put in, but it's not like decision, and not to mention some form of plastic kind of ID card or something. So how it's very dangerous, really, when you think about it, that if you can't really apply for a status yourself, how will you be able to use it to evidence your right to rent or to find employment or to open bank account? You can't really. So what is happening now is the least harmful for users way, for example, to evidence they have settled status for welfare purposes is to take screenshot of it, because there is no really a way to pass it on to DWP. As far as I can tell, there is still currently no channel to send the link, but even though it requires sending a link to someone who is able to receive a link and kind of log in, and it is quite complicated really procedure, quite frankly, even to describe it, not to mention to use it. So my question is, what will happen with users who even now might struggle with accessing online and mobile technology, not to mention what will happen with them in 20 years' time when they have to apply for social care, for example, support or something of that nature. So therefore we think that there is a big field of abuse and discrimination based on the fact that users will not be able to sufficiently use the status simply because it's only online product.
A digital application form is great. You know, it works for the majority of people, and this is what the Home Office's intention is. They want to get the majority of people through the system, and then at the end they'll start dealing with the more complex cases and start tweaking the system then at that point. But the digital application process and digital assistance is not going to help someone who's, again, that dual third country citizen who doesn't speak English but speaks Arabic, or someone, or a woman in fear of domestic violence, or someone who's trafficking, or someone who's working in informal working conditions, or an isolated citizen living in the middle of Northern Ireland. The digital assistance and the digital application form is not going to work for them. And the digital assistance still is all about helping someone fill in the form, but doesn't cover legal advice, doesn't cover how someone will get through the system. And this is where we always then fall back on the question, why is this not covered under legal aid funding?
Well, I was going to ask you about that in a moment. Can I just ask you firstly, however, about the accessibility of face-to-face services? I understand that will be available in centres. Where are those centres located, and are any of them located where I would like them to be located, that is in rural Wales?
So the Home Office have on their website, they've published a list of areas where you could get face-to-face assistance and also home visits, but it just gives us an area, so Essex, but it doesn't tell us where. And so you'll have to call up the customer resolution centre, say I have this issue, can you come out and see me, or can I come out and see you, and then you'll find out the details of where this is going to happen.
And the service is very strictly triaged, so if there is a slither of chance that maybe you don't need someone physically helping you, that you should do it yourself because you still have one finger left, kind of this level of sort of severity that again the effectively excludes people from the service and puts them in the future to possibly some sort of grey immigration area.
Yeah. Outside of the Home Office, there are some local authorities that are doing this themselves. So Bristol is one area where they've got a walk-in drop-in centre where people can sit there and ask for help filling in a form, and in some cases even get legal advice. So some local authorities are doing this because they feel that the Home Office are not doing this for them. So they're having to look after their constituents to try and get them through this process.
I just fear that people are doubly penalised who live in remote areas where not only they can't still access to online, but also the services just aren't there.
Well,
and I mean, for example, near my home area, there's a large Polish community in the Llyn Peninsula, which is about as far away as you can get from London as possible. And I have no idea what services.
Well, you see, this is a worry. Like the Home Office have issued this funding to those 57 organisations. But, you know, as well as the funding not being enough, because you're talking about £25 per head if you calculate how many vulnerable people may be in this. If you're talking about 200 to 300,000 people, that £20 per head is not going to really help a lot. But also those organisations don't cover all of these areas. And I did mention legal aid, but, you know, legal aid has its own issues as well, because legal aid won't cover, you're going to still have advice deserts in areas across the UK where there are no legal aid providers. But at least if you brought this back into scope of legal aid, we will then at least be able to tap into the sector that already has the reach and the resources and the staff qualified to be able to help in this. Whereas the Home Office are trying to mirror the system within the funded organisations and having the relationship managers and audits and so on, when the legal aid system is really fit and ready to do that.
Okay.
I think just one very small point about it is that we're very much focused on the lacking of availability of services and such, but there's been no clear information that's been brought forward by the Home Office of exactly how they've measured these issues, how they've identified the problems and the impact assessments of all of these particular problems. I've not seen any form of Equalities Act assessment or any kind of detailed analysis of a plan, and that's not been forthcoming.
Or on that, we've asked them and they refused to publish them.
Yeah.
Sorry, just on that very point, I understand there is a Freedom of Information request pending regarding those equality impacts assessments, but in the first instance it was rejected by the Home Office, so we're waiting now for an appeal decision on this.
Very quick question, very brief answer. The Welsh Government has set up a Commission on Justice in Wales under Lord Thomas of Cumgear, the former Lord Chief Justice, which is looking at, amongst other things, the provision of legal advice and the not spots for legal aid throughout rural Wales. Are you aware of this commission, and have any of you submitted any evidence?
Will be.
It's getting very late. Nobody else. Okay, thanks.
Thank you very much indeed. Seema Malhotra.
Thank you very much, Chair. Thank you very much for coming to give evidence today. And I know there's been quite a lot of technical discussion about some of the process issues and the variations in terms of support received. I just want to come back to ask a question about a policy challenge that we have and to get your view. And this is about the debate that we've had in Parliament about what happens in relation to citizens' rights in the event of no deal. And you'll be aware of the debates that we've had in Parliament, including the proposal by Alberto Costa MP that many of us supported, and including the government, on there being the joint UK-EU commitment as a whole to preserve the citizens' rights section of the withdrawal agreement, whatever the outcome. I know that there have been discussions, I think, certainly between the 3 million and also Britain and Europe, with the Secretary of State about this as well. It's one of those examples where there seems to be a sort of political preference for one outcome, but the sort of legal challenge is sort of in contrast to that. And there's been the recent exchange between Michel Barnier and the Secretary of State that seems to lend itself towards there being unilateral measures, again, between member states and the UK in the event of no deal. What is your view of the latest exchange of the correspondence between the Secretary of State, Stephen Barclay, and Michel Barnier on the ring fencing of citizens' rights, and whether you think we can still seek to move towards there being a single UK-EU agreement, or whether you think that unilateral agreements are going to work.
There's a lot there to unpack, and I'll probably start if I may. The correspondence that we've seen from Mr. Barclay to Barnier and recent runs, I think the key thing to take away is very open discussion. Nothing has been closed off, and a lot of the points that have been raised are quite technical, but they're not insurmountable, and I think that's the key thing to take away here. And I think what's quite important is that in this correspondence, particularly from Michel Barnier, there is no shall we say, emphasis on nothing is agreed until everything is agreed. It's very much about, you are aware that you'll be buying into CJEU oversight, you are aware that there are some technical problems that are here, but there is, legally speaking, there are no insurmountable issues. I think ultimately there is the politics, and there is perhaps the energy that's behind the government within the government to push this agenda. We've only had 2 pieces of correspondence since the House of Commons unanimously agreed to ring fencing. And whilst the content of that correspondence has been positive, there's nothing else around it. And indeed, Mr. Costa, in his most recent urgent question, made the point that there should be some form of task force to push this agenda through. The consequences of no deal, I mean, there are papers that we can give you that will clearly set that out, and indeed my colleagues at British in Europe, who will be speaking after us, will emphasise particularly the significant problems that lie ahead if there is no ring-fenced agreement. But one thing that I would like to make a very clear emphasis on is that there is a ticking clock. That the opportunity to ring-fence citizens' rights and protect those rights as EU citizens in the UK and UK citizens in the EU must be done before we leave the European Union. So there is a very clear political impetus that needs to be injected into this, because there is a very serious urgency to it. Now, you asked, I believe, about the unilateral measures that would be implemented in the event that there is no deal, or indeed no ring-fence deal. Again, my colleagues at British in Europe will be able to speak to the unilateral measures in member states and the consequences therein. As far as in terms of the position from the UK government, we simply have a policy document, which I'm sure you will have seen, which seeks to essentially erode further the rights of EU citizens in the UK by limiting their ability to bring families to the UK, and indeed limiting their ability to challenge decisions. And this is a point that we touched on earlier. And I think the point really to drive home with this is that very much the promises and the issues that were said, this is what's going to happen when Brexit was decided upon, was that nothing would change for EU citizens. And what we will see, the withdrawal agreement doesn't exactly preserve 100%, but in the event of no deal, then it will not be the same. There will be a very distinct difference between the rights that EU citizens have now and what there would be if there was no deal.
Thank you.
That's great. Stephen Timms.
Thank you, Chair. Can I ask you about the problem that some EU citizens had in voting in the recent European parliamentary elections? I've seen an estimate that 1 million people might have been affected by this. Can one of you explain to us what the problem was, and if you have an estimate for how many people were affected, what is it?
I mean, what the problem was, it was to do with the process of registering EU nationals to vote in European Parliament elections, specifically in the UK. So it's related to the so-called UC1 form, which is an additional form that you have to fill in, or a EU citizen has to fill in, to certify they wouldn't vote in their country of citizenship as well as the UK. So the problems with that are, first of all, it is a separate form. It's not on the voters' registration form. So one may register to vote and still not be eligible to vote in EP elections. Secondly, the UC1 form expires after 12 months. So even if one has registered in the past, their form would not be valid for the next EP election, and as a matter of fact, it expires after 12 months. And there was very low level of awareness of that form amongst EU citizens, because because of the timetable of the election, the electoral offices didn't have much time to send those forms out. So as a result, we think that at least tens of thousands of people were disenfranchised. You mentioned the figure of 1 million. Our understanding is that it is actually quite hard to quantify specifically, so we would rather not throw around those kind of figures. But what we can tell you is that immediately after the election, we ran a survey. From 900 responses that we received, 194 councils registered irregularities out of 382. So
sorry,
more than
say that again.
194 out of 382 registered irregularities, and that's just a sample of 900 people that replied to us. So what it means is that...
Sorry, you're saying the councils registered irregularities?
Yes, so we had reports of irregularities and votes denied from 194 councils
so
out of 382, so just over half, and that's just our online survey. So this would, and indeed they were quite equally distributed, though the only clustering was where there is actually quite a lot of EU citizens or politically engaged EU citizens. So it indicates that the issue was really systemic. We know of councils where well in excess of 1,000 people were denied the vote, either because their forms were received or processed too late and rejected, or because they weren't informed that they had to fill them in the first place, or because they assumed that their forms would be valid because they had already filled them in, being registered at the same address.
Similar problems arose in 2014, and at that time, I think, there was an assurance given that this UC1 form would be sent out to EU citizens who are on the electoral register. Who was it made that promise? I mean, clearly it didn't happen, but who promised that was going to happen?
There was there were several there were several levels of trying to push for a change to this process, which indeed caused the same problems in 2014. The Electoral Commission was making a commitment that they would change this form, possibly making it valid for 5 years, the full election cycle, or implement further changes. But also there was an exchange between the UK government and the European Commission on this, and that wasn't followed up. So we understand there was the Vera Jourova letter that was publicized in the press, I think, about a couple of weeks ago, which indicated that the Commission expected changes to be implemented, and that also did not happen. So it was the UK government that effectively made the commitment to change this, and then this change wasn't enacted upon because we didn't expect to have an election.
Can I just, a final question, if I may? I mean, would it have been permissible for councils to have had these UC1 forms at the polling station, so that people could have come in, been told you need to fill in this form, filled it in, and then voted? Because quite a lot of people did turn up and only then discovered they couldn't vote.
No, that wouldn't have been allowed because the councils then have to process all those forms and exchange information with other EU member states. So therefore, they have to notify other member states before the election takes place. So on the day of the election, it would not have been possible to do that.
Okay. Right. Good. I'm just very conscious we've got a second panel, and really quickly.
Were the British government alerted to the problem with the UC1 form in advance of polling day?
Yes, of course. I mean, there was that discussion 2014, 2015 after the Electoral Commission's report came out, and also immediately before the election we lobbied the Electoral Commission. We sent a complaint to the Electoral Commission before the election day. All that fell on deaf ears, I'm afraid.
Right, thank you. And finally, Sammy Wilson.
Really, an alarming statistic which you gave us, Barbara, that so far, if you take that there are 3 million EU citizens living in the UK, only a quarter have applied. If you take your inflated figure of family members, only an eighth have applied. You've outlined some of the difficulties, but what further can be done by, first of all, the EU, secondly, by the embassies of the countries from which those people have come, and thirdly, by organisations such as yourselves to try and ensure that people who currently have not even started to register can be encouraged to register?
Well, so coming sort of from starting with organizations like ourselves, first of all, it would be mainly outreach. As I said, I would put the main onus of communications on Home Office, but outreach, so reaching those who are most excluded, is probably responsibility of as much communities themselves as it is of anyone else. In terms of consulates and embassies, it depends on their legal status and what they can do, because, for example, Polish law does not allow consular service to provide advice on other law than Polish, but there is still venue to provide some awareness-raising activities or just passive awareness activities such as leaflets and this sort of materials that don't put the staff in breach of the local law applying to the country. In terms of the European Commission, I suppose it's I don't really have any comment on what would be the role of European Commission. Quite frankly, I don't know whether Chris would mention that, but that's essentially awareness raising. But it will not work unless we extend deadline anyway. There is still quite high dynamic in terms of migration movement, in sort of migratory movements between the EU states. So we really don't know what sort of numbers we are talking about at the end of the day.
We accept that the EU Commission, for example, has spent all kinds of money on even for drama groups putting out anti-BrExit messages. So it wouldn't be unusual for them to help their citizens in becoming aware of the need to apply for settled status.
Well, on the Commission side, they have since January 2017 have run various communication campaigns on this, and they range from social media campaigns. So if you look at all of their social media profiles, they're constantly advertising about the scheme and the requirements of the scheme, and they also have putting case studies on there so it can relate to people who have similar situations. It also moves on to public information sessions. So there's been over 200 of them all across the UK, and the minimum requirement for attendance is at least 40 people, but we've had attendances up to 500 at one of these sessions. As well as that, each embassy are running their own individual campaigns on social media and so on to try and get this message out as far and as wide as possible. So there's a lot of work being done on their side, but there's also the view that this was a decision made by the UK, and that it's the responsibility, the primary responsibility for communications and to ensure that everyone registered in the scheme is registered by the deadline is on the Home Office. So all of the work that they're doing is a lot, but it's meant to supplement what the central government and the Home Office are meant to do because it's their responsibility.
Right. Can I just very quickly say that we're discussing here how to tweak the implementation of the scheme that I don't think anyone here believes that can be fully implemented ever. So we will never get everybody to apply to EUSS. That is the grand truth that I believe this committee has to recognize, and whether we agree with this or not, that's another matter. But what we're saying is we'll never be able to reach everybody, however hard we try, whether the European Commission is on it, whether the embassies are on it, whether we are on it, there will be people who will fall through the cracks. And the main task is to decide whether we're comfortable with that or whether we're not, and what then do we do if we're not comfortable with that to avoid that situation. We believe the declaratory system is the only way forward, as we have said multiple times. But
just on that point, you would accept that even if you move to a declaratory system, some people might fail to declare and they'd still fall through the cracks. So that is possibility, isn't it? Just one very final question from me. If someone's been given pre-settled status because they've got 3 years residence, and in 2 years' time under the current scheme they then make an application for settled status, they take the initiative, then the system would accommodate them doing that, yes or no? Yes.
Unless there's something horrifying happened, they have acquired some, because with people's situations might change. The second application might fall after there is some serious criminal conviction, for example. So it's not an outcome that is obvious.
It's a criminal conviction, but in terms of the way the system works, you can do that. But is your understanding currently that the Home Office will not automatically give, when 2 further years have elapsed, settled status to someone who's had pre-settled status because of the example you've just given? They might have a criminal conviction, or they may have been out of the UK for 12 months during that period.
Effectively, one has to apply this, go through the same procedure
again. The same
again,
procedure
basically.
again. Fine. Okay. You've been extremely helpful. As I promised you at the beginning, we had lots of questions to ask. Thank you for your evidence. And could I invite the second panel to come and take their seats? Right. Well, thank you very much. On behalf of the committee, can I express our thanks to our second panel today for coming to give evidence. Could I say, in particular, I would like to thank the British in Europe group for the very comprehensive piece of work that you have put together on the rights of UK citizens in different EU countries and their plans. This is and will be extremely helpful to the committee in considering the matters we are talking about today. Can I welcome Fiona Godfrey, co-chair of British in Europe Luxembourg, Jane Golding, well actually no, Calba Meadows is next, the steering committee, British in Europe from France, Jane Golding, co-chair of British in Europe from Germany, Jeremy Morgan, vice-chair British in Europe, Italy, and John Richards, steering committee, Euro citizens from Spain. You are all very welcome indeed. Can I begin by asking you this question? Listening, because I think all of you were in the room for the previous evidence session, listening to the circumstances of EU citizens here in the UK, how does that compare with the current position of British citizens in the 27 other member states? Better, worse, kind of the same? And
I think it's a bit more complex than that.
More complex, okay.
Obviously, we are living in 27 different member states.
Sure.
So how I would sum it up is that as a European version of the postcode lottery, we will be treated differently in each country.
Right.
In the case of a no deal. In the case of a deal, obviously, there is a framework at UK-EU level. Some countries will take one system, the declaratory system, and others will go for the constitutive system.
Now,
can I just add something to that? In terms of what you have is had a fairly detailed discussion about a scheme which has started and the rules for which have been laid down. There isn't, I think, I'm probably wrong to say there isn't a single European country in which that has happened. We are mainly looking at potential systems which might kick in when a Brexit happens with no deal. That's the main focus has been on that. So we literally don't know the detail in the same way as EU citizens do here, for the most part.
Now that's a very important point. So would it be fair to say that the position of British citizens in the other 27 countries is behind, or way behind, the position of EU citizens here in the UK?
Behind in terms of time, in other words.
In time, but clarity about
yes.
what they need to do and what rights they will get if
yes.
they do it. Yes?
Yes.
Right, now which member state would you say is doing least well in explaining to British citizens what the system is going to be, ease of application? Because since you said, Ms Golding at the beginning, quite correctly, it's going to be different in different places. We are interested in the detail, and your document does cover that. Who really needs to pull their socks up in terms of the other 27 member states?
Well, I mean, again, it depends.
Well, this is your chance.
Yeah. I mean, again, it depends on that. You have to look at the detail. There are, I mean, what we've explained in the paper is that there are some countries that, to date, haven't adopted any legislation, other than perhaps emergency legislation. And those countries are Germany, Cyprus, and Romania. They will adopt legislation on Brexit date, on the withdrawal date, if it happens. Then there are other countries that have adopted legislation, but they state in the EC table that we also link to in our paper that there could be some movement on what has been proposed depending on how the negotiations develop, depending on whether there might be some form of EU-UK coordinated solution. Then there are other countries that have perhaps adopted quite detailed legislation, for example, Spain and France, but which make very clear that what has been adopted, the framework that's been adopted, is subject to reciprocity, and in particular reciprocity as regards the citizens of that particular country here in the UK, but in the example of Spain, for example, it's reciprocity across the board. And John Richards can give further detail on that.
Just on those two countries, since you mentioned France and Spain, looking at what is happening in the UK at the moment and the evidence we've just heard, would those governments say, it looks like there's reciprocity in the UK for the purposes of the laws which we have passed, or not?
Can I speak a little bit for France?
Yes, please.
The feeling we're getting, talking to French officials and French politicians, is that they are not yet happy to say, yes, there is definitely reciprocity. They don't trust the UK. They feel that the UK has a policy of withholding rights rather than granting rights. They would really like to see EU citizens' rights enshrined in primary legislation. So there's a very big concern about reciprocity in France because, as Jane has just said, it's reciprocity with EU citizens here in the UK, but it's also reciprocity amongst goods and provision of goods and services. So if, for example, the UK doesn't reciprocate in the provisions that France has put into place via legislation on provision of goods and services, transport of people, transport of goods, then British citizens living in France could see their rights in a no-deal Brexit suspended.
Transport of goods?
Transport of goods.
Could you clarify, just explain what you mean by that?
Under the French no-deal legislation, there are three aspects. There's an act, which sits at the top. Then there's an ordonnance, or several ordonnances, and then there are decrees which explain the functioning of each ordonnance. So under the Act, there are ordonnances covering citizens' rights, transport of people, transport of goods, and a number of other things. The Act makes reciprocity contingent on citizens' rights, different aspects of citizens' rights, and transport of goods and people. So, and each of those has an ordonnance which has a very clear statement of reciprocity in it. So, for example, under transport of goods and people, if the UK doesn't reciprocate on citizens' rights for French citizens, those aspects of transport and goods and people would also be suspended in the UK, in France. So there is it's a extremely worrying thing obviously for British people living in France, because our rights in a no-deal Brexit are contingent on the UK playing ball on transport issues.
But isn't that a bit unreasonable to say that the rights of British citizens in France might be held hostage to a failure to agree something on the transport of goods when we're talking about the rights of citizens? I struggle to see the connection. I can see why a member state might say, we'll look at how you treat our citizens and we'll treat your citizens the same, and that would be fair and reasonable. But to bring in, that's why my brow furrowed at that point, the question of the transport of goods. Is that to do with tariffs or lorries or what? I don't see the connection.
It's to do with the actual ordonnance covering transport. It's to do with three things. It's to do with the right of British operators to operate on French soil, the right of British operators to transit France carrying goods or passengers, and the right of British operators to transport between the UK and France. It's those three very specific things that are subject to reciprocity.
Right. Okay. Now, Mr. Richards, Spain.
So far as Spain is concerned, on the 1st of March they adopted a decree which is designed to avoid there being a legal vacuum for a number of areas. Those include citizens' rights, but also other areas, police and judicial cooperation, financial services in part, and also, as Calba has mentioned, there are transport aspects. Spain is obviously concerned about reciprocity because the decree has basically a number of levels of reciprocity. There's an across-the-board provision in the opening part of the decree which says that within a 2-month period, if an assessment is that there isn't reciprocity across the board on all the areas, so a rather similar approach to the one my colleague mentioned, there is the possibility of revoking the decree. But I think perhaps more relevantly for these sort of discussions, when you enter into the specific parts of the decree dealing with things like social security, rights for employment, pensions, those normally all have a specific last paragraph which says and what is being done is done contingent on the UK also providing similar treatment for Spanish nationals resident in the UK. And there's a final sort of reciprocity aspect in that there's a 21-month grace period to apply within the decree. And during that period, there are a number of rights relating to pensions, social security, and health in particular, which are maintained, but they're also contingent on there being some form of bilateral arrangement agreed during that time to be of a more permanent nature, whether it's bilateral or whether it's a multilateral framework agreement. But that means at the end of the 21-month grace period, a number of areas which are certain during that period in terms of your rights to healthcare, social security and pensions, they have to be dealt with. So that's not quite reciprocity, but it's another aspect of uncertainty, if you like, being entered into the system. The decree is adopted to cater for a no-deal situation, and I'm not sure that I can't speak personally, but I'm not sure the Spanish authorities have embarked on an at this point measuring of reciprocity. I think their ideas of reciprocity will be if there is no deal and if their decree then comes into force, that they will take it on the basis of what is written in their legislation.
But so it is possible that in the event of no deal and after 21 months, that the right of British citizens living in Spain to, for example, healthcare would end? Would the Spanish government actually do that, do you think?
I think it's a question of... Spanish legislation, as I understand it, has a relatively generous provision for healthcare of people who are in the country, but it's more a question of who pays, and it's more a question of whether the existing arrangements will continue or will not. And the decree provides that the current system will be regarded on the Spanish side as being one which is to continue. But within the 21-month period, there needs to be something which I think deals with things on a more permanent basis. That's my understanding of the situation.
Are any of the rest of you aware of anything similar in relation to rights to healthcare that might be at risk in other EU member states in the event of no deal?
Yes.
You go ahead.
Well, in the Italian legislation, which is, unlike the Spanish, the Italian legislation on Brexit rights for citizens is probably 2 sides of A4. It's very, very brief indeed and contains very little detail, but it does deal with the continuation of the S1 scheme, which is the reciprocal healthcare scheme in the EU for the country which pays a pensioner's pension to also be responsible for the cost of healthcare administered in the country where they're living. And the Italians have a provision in their law which extends that until the end of 2020, subject to reciprocity.
It's also potentially an issue in Luxembourg for people insured under the S1 scheme as well.
And it's potentially an issue in Germany. I mean, the situation at the moment is there is an emergency legislation was passed which did cover some issues post withdrawal date, and one of those is healthcare. I think what the German authorities are hoping for is ultimately that there will be some form of reciprocal arrangement at EU-UK level or bilateral arrangement. However, obviously the S1 scheme at the current state of affairs would fall away, and the only option that would then be open to S1 holders is to switch to a German health insurance company, but that would be at a cost, and they would have a 3-month window during a grace period following withdrawal date in order to make that decision.
Now, listen to what you've said. What would you, as an organisation, say to those in the UK who are advocating that, to borrow a phrase, come hell or high water, we should leave either with a deal, but if not, with no deal on the 31st of October, come what may? Where would that, leaving on the 31st of October without a deal, leave the people that you are representing here today?
I would say that the overriding issue, it would leave us in a significantly worse position than a deal, significantly worse, and the overriding issue would be the uncertainty of our situation. Grace periods might come into place in all of the EU 27 at that point. However, we, in many countries, have no idea or have little clarity about what the final permanent status would be.
So, I don't know whether you've taken the view, but would a no-deal Brexit be something that you would recommend on behalf of the people you are representing here today? Well, just for the record, your facial expressions, but if you could, would you recommend a no-deal Brexit?
No. We would absolutely not recommend.
Any of you? No.
No-deal.
So 1, 2, 3, 4, 5 witnesses saying you would not recommend a no-deal Brexit. Do you think that point is being heard by those who are making this argument?
It's very hard for us to say. It really is. It's not featuring high in the list of topics of discussion, if I can put it that way.
Right. Okay. Now, that is extremely helpful. Peter Grant.
Thank you, Chair. Good morning, everyone. Thanks very much for coming in to give evidence today. There's two different views that you can take on the responsibility of your host countries to protect your rights. One is that the government of France, Spain, Italy, Germany has got a responsibility to you, regardless of what happens anywhere else. Another is that they didn't cause the problem, and that it's reasonable for them to wait and see what approaches the UK government makes to their citizens on the basis that it's not realistic to expect Germany to treat British immigrants in Germany significantly differently from Britain treats German immigrants lying here. What's your take on that? Obviously from your individual interests, you would like your host countries to give you an absolute guarantee of everything, but as an organisation, where would you put yourselves on that spectrum from, on the one hand, saying it's entirely up to the British government to fix it and other governments will follow suit, or the argument we get from some people in the UK, which is, regardless of what Britain does to immigrants living in Britain, that British immigrants living overseas should have the rights protected unconditionally by the host countries?
I think primary responsibility lies with the British government, our own government. We are British citizens, and so far we have been very badly let down, I think it's honest to say, by the British government's response. We are losing a whole set of rights because of red lines laid down by the British government, and there is a lot more that they could be doing to protect our rights. I think it varies from country to country, but on the whole, our host countries have shown a degree of flexibility and understanding for our position, but they are increasingly hardline, given what is happening, or rather not happening, here in London, and given the lack of political decisions that are not being taken that we need to be taken. So ultimately our host states are saying we will do what we can, but they are not going to go out on a limb, especially when they are still concerned about the fate of their own citizens. And just to go back to the reciprocity point, even though legislation in other countries doesn't overtly mention it, when you sit in meetings with these governments, they are very, very clear that they will also act on reciprocity. So we are living in limbo 3 years on, and we're really looking to our own government to provide some answers and support, because that has been sadly lacking.
Thank you. Anyone else want to add to that? I saw quite a lot of nodding from the rest of the panel. Does anyone want to? Would anyone sort of disagree with anything that Jonas said?
I don't think, in a sense, we're so concerned about who's morally responsible for the state we're in. We are really concerned about the effect of the debate upon citizens' rights, and I think it's got to the stage where our initial call, and that of the 3 million, was that we should not be treated as bargaining chips, and increasingly as this game plays out, we are more and more becoming bargaining chips, and that's a real concern, for which I wouldn't want to say it's the British fault or the EU's fault. It's a process which is going on, and frankly it should not be going on, because citizens' rights are above that, and both sides promised from the beginning that they would be above that, but it's not happening.
Thank you. We heard evidence previously from the 3 million that regardless of what the UK government was saying, that migrants here were always made welcome, would have their rights protected, that there had been a very worrying increase in incidents of xenophobia and racism directed not only against EU migrants living here, but against migrants from other countries, and frankly against anyone who looked as if they might have been a migrant. Have you experienced anything similar directed against UK nationals living in other EU countries since the referendum, or as a result of what's happened since then?
I think it's fair to say no, we haven't. We haven't experienced anything at all along the lines that EU citizens here report on a pretty much daily basis. I think most of us feel our countries as a whole still welcome us as people on a personal level, even if there are political issues about how to protect our rights. On a day-to-day basis, we have asked all our member groups whether they've got evidence of discrimination, and very, very little has come up apart from some discrimination possibly in the field of employment rights in Belgium that we mention in our evidence.
Pardon, I don't mean to interrupt. The acoustics are very poor in here. If you could maybe speak a little louder and a bit closer to the microphone, that would be really helpful.
Yeah,
thank you.
Okay. But yes, on a level of day-to-day living, then no, we are not experiencing discrimination.
The example of employment rights that Carver just mentioned is quite interesting, because it's very practical. It's people saying to British employees, well, your future may be in doubt because we don't know what's going to happen down the line. People who are applying for jobs, not getting them because they're British, and there may be a problem. So it's that sort of rather practical thing. It's not a, if you call it racist, whatever, it's not because we're British that they don't like us that things are happening. It's because there are practical concerns about the future, which mean that it might make more sense for a particular company to employ someone different.
And employers are, in fact, we have heard instances of employers contacting their employees to say, when the UK withdraws from the EU, you will have to present us with a residence permit, and already warning them of this issue.
Okay. Would it be fair to say, in fact, that the kind of approach that you've described that some employers are taking towards hiring employees who are British citizens, is it similar to what some businesses are doing in their setting of trade contracts? They don't have an issue with taking on a contract with a British supplier just now, but they're a bit concerned as to whether the contract will be deliverable in the future. Is that what you're saying? It's more a kind of a practical issue that they might give a job to a UK national who becomes an illegal resident in a year's time, and that the employer then has to sort it out. It's certainly an interesting comment, and I think you've mentioned that in the evidence document you submitted to the committee a few days ago, so that will be recorded as part of today's evidence. One sort of final question, and the Chair kind of touched on it earlier on. At the moment, you're all living with full citizens' rights in a collection of countries across Europe. simply because you got citizenship of one of 28 countries. As well as those who are suggesting that we leave at the end of October, regardless of what the consequences are, there are some who've been saying pretty much since the day after the referendum we could just hand in a notice immediately, walk out, and it wouldn't make any difference. If the UK was to leave without a deal next week or next month or at the end of October, leaving aside for a moment what we would all hope the reaction would be from your host countries, what rights do you have as a UK citizen living in an EU country on Saturday if the UK walks out without a deal on the Friday? As a matter of actual law, what legal and enforceable rights do you have the day after we leave without a deal?
No. Well, the first things, I mean, the really major things that we have at the moment are free movement, the right of free movement, obviously. So that gives us the right to work across the whole EU 27. It gives us the right to have our professional qualifications recognised across the EU 27. It means we can work cross-border. It means we can provide cross-border services. So in terms of employment, that would be huge rights that would fall away, and that would only be, I mean, certainly free movement would not even be covered by the withdrawal agreement, and some of these issues are not fully covered by the withdrawal agreement.
Okay.
And if it was no deal, you'd have the additional problem that, as we've said, we face uncertainty. I think a lot of countries are doing a wait and see. Let's see what happens by September, October, and perhaps fill in the gaps. At the moment, those gaps would be not filled in, and they would have to start thinking very hard and very quickly about rights. And I would imagine the consequence would be that for issues of healthcare, issues of social security, all sorts of issues of getting into the country, all sorts of practical problems, you would have a very mixed bag, because there would not be enough central direction in the countries to lay down what should be happening.
Okay. But you would no longer have the guaranteed rights under the EU treaties?
No.
No.
Okay, so you would depend on the sensibleness or reasonableness of your
Well,
those
it would
countries.
depend also on the laws which, insofar as they had been legislation in the various countries, they would generally kick in automatically. But our point there is that, for the most part, there remains a great deal of uncertainty even with those laws.
Okay.
To be even clearer, without any contingency legislation, we would become illegal.
Right, so does that apply to all 27 states? Are there some EU member states where British nationals face the prospect of no longer having a right to live there the day after?
If a country has no legislation in place, no grace period, then at the moment the UK leaves without a deal, the UK citizen has no rights because they haven't entered that country as a third country national, and they haven't gone through the process of obtaining a visa, obtaining a residence card as a third country national. Hence the importance of the contingency legislation, which actually stops there being a cliff edge between being legal and illegal.
We've got other colleagues who've got other parliamentary business who do want to come in. Jeremy Lefroy.
Thank you. Just very briefly, thank you very much indeed for the extremely helpful document that you produced. I notice, this would have probably been obvious to those people who live across the EU, but not for many others, that the rights for holding dual nationality clearly are very different from one country to another. And I notice, particularly in the case of Spain, that after leaving the EU, in fact, Spanish citizens living in the UK will have rights after permanent residence in the UK for 5 years to apply for UK citizenship, but the converse would not apply for British citizens living in Spain because of their rules over dual nationality, and the same seems to be true in other countries as well. Is this something which is commonly appreciated by British citizens living across the EU, that there are these big differences in application for citizenship and holding of dual citizenship? And is it your appreciation that this is known to British citizens more generally who might be thinking of going to work in other EU states? Perhaps Mr. Richards, because...
Well, I mean, just to start, because others will have also comments, Spanish nationality is something which is a long period of residence. It's 10 years, shorter if you're married, obviously, to a Spanish person. Then there are cultural and linguistic tests, but that's common to most nationality systems. But you have to give up, if you're British, you have to give up your passport. Certain nationalities can retain their passports, but those are more those with South American, shall we say, connection. They are traditional countries with which Spain has other links. So you'd have to renounce your British nationality to get a Spanish passport.
But it wouldn't be the case the other way round.
But the other way round is that you do not have to renounce your Spanish nationality if you, as a Spanish person, take nationality in the UK. So Spanish citizens living in the UK have a shorter residence period. They have a relatively hefty fee, but they can obtain UK nationality in circumstances where a UK resident in Spain has a rather different, more cumbersome, much longer procedure where dual nationality is not a possibility. So you ask the question whether people appreciate this, and I think certainly in the UK there tends to be a bit of an off-the-cuff reaction of, oh, why don't you just apply for nationality? Surely they'll give you nationality. That's obviously, from what I've described, not an appropriate response.
Right, so just to make perhaps a point about reciprocity, actually, in many cases it's not going to exist because UK citizens will have worse rights reciprocally than Spanish citizens because a UK citizen going to Spain wishing to take up Spanish citizenship would have to renounce UK citizenship, whereas the reverse is not the case. So I'm wondering quite how this reciprocity actually applies, or whether it's only applicable in certain areas and not where it favours the EU 27.
I don't think it's not designed like that. I think the idea is that reciprocity is not really a matter for the Brexit debate. Reciprocity on citizenship is not a matter for the Brexit debate. Citizenship is, par excellence, a national issue which each country decides, and the EU.
I just wanted to make that clear because it's
role in.
It's quite clear from your paper that there isn't that in terms of citizenship. All we're talking about is EU citizens' rights, but actually, the taking of citizenship is something that clearly your members are having to consider. And have considered in many cases, and it's very different from one country to another.
Yes.
Yes, that's absolutely right.
You could make a parallel with voting rights, and we know that there have been, 3 agreements, I think, made recently, bilateral with Britain and certain EU countries, to enable voting rights in local elections to continue. That's because it's not an EU responsibility, and therefore it's a matter for each country to decide. Citizenship is very much in the same camp. It's a national issue which the EU does not interfere with.
So do you think that this difference between things that are national issues and those which have come out of our membership of the EU, that is understood sufficiently and made clear both by our government when interacting with EU citizens in the 27 and vice versa, or are the two sometimes mixed up?
Very hard to say.
It's very hard to say. I think sometimes it is mixed up, and I think a lot of UK citizens who don't actually understand what's going on at UK-EU level in terms of the negotiations or contingency plans, for them they see citizenship as their insurance policy. And they don't completely understand how that relates to everything else that is going on. That is true to say.
And they don't necessarily appreciate also, as we point out in the paper, that even if you are fortunate enough to be able to become a dual national, that's not a panacea for everything. There will still be rights that we will lose even as dual citizens, such as surrendersing rights, for example, spousal reunification.
Or professional qualification. Because you can change your citizenship, that doesn't change the origin of your qualification.
And just finally, it also seems that in some countries, such as Belgium, different local authorities might take a different approach to applications for citizenship. Is that the case? That seemed to come out of the paper.
That's mainly related to British citizens who have been EU officials because they hold a different type of residence card. So there we can see a clear difference between the approach of the Belgian government and the Luxembourgish government. In Luxembourg, that special ID card for EU officials, British EU officials, is enough to recognise the 5 years of residence needed to acquire or apply for citizenship. The Belgian government, up until recently, has not been recognising even 30 years residence under that particular card as residence sufficient to acquire citizenship, but there have been court cases now. So it is being worked out, but in some communes and some areas you still have to kind of threaten to go to court before you are granted citizenship.
Thank you. Okay, thank you very much. Seema Malhotra.
Thank you very much, Chair. I just have a very brief question for you, and thank you for coming to give evidence to us today. The Chair wrote to the Foreign Secretary in May and asked for an update on the progress with plans in each member state, and the Foreign Office had overseen a series of almost 500 outreach events for UK nationals over the last sort of 18 months. I was just interested to know whether you had attended any of those events, whether you felt that they picked up all the issues, and certainly we've been through the key issues, which do vary slightly by country, but are still sort of broadly similar around residency, pensions. Perhaps we haven't talked as much about that, healthcare, travel, and free movement. Was that an effective process? Does it need to continue? And what would your feedback be, perhaps, if there was anything that you felt hadn't been brought out as much in terms of what's of most cause for concern for citizens, UK citizens?
Well, perhaps I can start with Germany, because I'm also, as well as being co-chair of British in Europe, I'm also chair of British in Germany. And British in Germany, with the embassy in Germany, we've cooperated on a large number of events across Germany. Of course, Germany is a federal state, so there will be differences in the approach from land to land, and so we've been trying to cover as many areas as possible. I would say that there have been a lot of events, which is good, and I would say that some of them, until recently, focused too much on the withdrawal agreement and not enough on no-deal contingency. I think now there's been more focus from the embassy side on no-deal contingency and what they have done with us and with German authorities, for example, in Berlin in the last few months, is actually organise info fairs, so that people can come along. There's a very short presentation at the beginning rather than a long speech about what the current government position is. There's people can go to stands where they can actually talk to German officials about issues like residency, insurance, health insurance, employment, professional qualifications, all of those different areas. And I must say, I think that is something that people in Germany, our members, have appreciated that approach, and it would be good to be going. Those sort of events are needed more and more cooperation with the authorities in country, and more focus on being able to answer people's individual questions when they come along to an event.
Yeah, I'll talk a little bit about the situation in France, which is not quite so developed as the situation in Germany. We have a very different population. We're a rural population. So British citizens in France are spread over a really, really wide area, with some living an hour, 2 hours from a big centre of population, which means that events that have been arranged don't necessarily have a very large catchment area for people. One of the big problems has been they've often been arranged at very short notice, sometimes a week, 10 days. They've often been arranged during working hours. So we've noticed that the numbers of people attending have been decreasing, whereas when they began, we were perhaps seeing 100, 200, 300 people. They were selling out. Now it can sometimes be 20, 30. So there's a kind of... a vicious circle where fewer people are attending, so fewer events are organised. They don't have a terribly good feedback because they don't. People say to us that they're not really addressing the issues, so therefore people don't go. Another problem is that they are only advertised via social media, Facebook particularly, and you're simply not going to reach all British people living in France via social media. And of course that leads on to a whole big question about communication and outreach, which if we've got time it would be good if we could come back to. So yeah, we don't have the same very positive reports that Germany has. It could do better.
I think, speaking for Italy, we have had a lot of outreach meetings. Again, it's a population which is difficult to reach. It's partly rural, partly urban, but spread all over a very long country. And so the meetings tend to be, if you get 30, 40 people, you've really done quite well. And we've had the same experience from British in Italy organising our own things. I think one of the problems was that certainly in the early days there was a great tendency to sell the party line. So, for example, I remember the ambassador giving a talk about a week before the second of the votes in the House of Commons on the withdrawal agreement, where it was fairly clear from the press that it was highly unlikely to be passed, being confident that it was all going to go through. That kind of thing's not helpful because people are realistic. There's been a great improvement, I would say, over the last year, with much more focused attention on rights. There's always the problem that government spokesmen have, not perhaps going too far. By and large, if you wanted to find out what your rights are in Italy, you're better off looking at a British in Italy website because we can be franker and clearer, or we can express doubts, whereas because of the desire for the government to maintain the relationship with the Italian government, they'll perhaps be rather more cautious in their wording. As I understand it, there's, for example, there's a living-in guide in relation to each country in the EU27, which is it's organised by the FCO, but you get it through your local embassy website. That is all vetted by London, and so it tends to be a bit bland at times and not helpful.
So far as Spain is concerned, I think the British Embassy has made a lot of effort in respect of outreach, because there's quite a large population. But I think their main thrust has been to try and ensure that those who are resident but who haven't been through the Spanish formal residence procedures but are really living in Spain do get formally registered, so that they don't fall into a position. So basically that they can take the benefit of either, the assumption was originally the withdrawal agreement, but now also it would be this decree, because they will already be within the system and so continue. So a lot of effort was put into that, but a lot of information has been given. I would agree that as representatives of the British government, you're obliged to have a sort of party line approach, which I think is difficult to avoid. And there, I think residents also use the filter of our associations. There are associations on the coast. Mine Euro Citizens is basically concentrated on Madrid, and we've all had a lot of interaction, both with the British authorities in the form of the embassy and the Spanish authorities. So there is a way that people can get information. We all have meetings of our respective organisations, and well attended from time to time, less so on other occasions. But I think that combined with the fact that the Spanish government has a really rather comprehensive website, and echoing back to a linguistic comment made in the earlier panel, it's also fully in English, so that if you are an English speaker, you can look and you can see the basic components of this decree laid out. So it's not that people are living completely in the dark, but of course things can always be better. and people are always concerned about their situation. And there is an element of uncertainty that just can't be explained however much outreach you have.
Everything that's been said previously is true for Benelux as well.
Can I ask you about the declaratory system that some member states are using? How does that work? And where does that then leave those who have declared when it comes to paperwork to show that they do in fact have the right to be in the country they've been living in for quite some time?
I think the answer is don't know, because it hasn't started yet.
So nowhere has it started yet?
I don't think it has. I mean, people in Holland have received letters.
Yeah, in Luxembourg as well. In Luxembourg and the Netherlands, letters were sent out to every British citizen by the government. But, I mean, we have a system of registration in most of our countries, so most of us are already registered anyway. But the withdrawal agreement declaratory system has not started yet. Or constitutive, yeah, go on.
Can I just add something to that? Well, the declaratory system is a system that we have across the EU 27 now under EU law. I mean, declaratory of our rights as EU citizens. And, I mean, it's been working for a very long time. It doesn't seem to cause any problems. And part of the reason for that is because there's a misunderstanding that a declaratory system doesn't mean to say that you can't, that the country and your host country can't insist that you're registered. And in most countries, there may be a declaratory system under EU law for EU citizens currently, but there is also a mandatory registration system, which is exactly the system that could be implemented under the withdrawal agreement if the choice was to go down the route of the declaratory system.
Right. But if someone said, show us that you have the right to reside, to work in one of the 27 member states, what would British citizens be expected to produce? Bearing in mind you've just said we don't know, but presumably there'd have to be some documentation.
Well, the documentation that I have to provide in Germany now, that I am registered under the mandatory registration system, is a simple document that shows I am registered. In other countries, there are actually forms of cards, of registration cards, and perhaps...
So it wouldn't be...
You can explain, Jeremy, the system in Italy.
Well, now suddenly they're all coming out.
Yes.
Put your cards on the table. Indeed, indeed. So it's declaratory, but with a document.
Yes.
So even for those who are declaring, who are arguing that there should be a declaratory system here in the UK, for the other countries where there may well end up being one, it will still involve a document.
It will involve a document. It just won't involve an application that could be rejected.
So you get the document automatically?
It's a simple registration system. If you're fulfilling the conditions under EU law, then you will get your document. But you don't have to apply for the status.
You said fulfilling the conditions under EU law. If you don't fulfil the conditions, you might be rejected for the document. Is that right?
Yeah.
Yes. So, right, okay. A bit like if you're applying for settled status under the current scheme here in the UK, if you fulfil the conditions, you get it, and if you don't fulfil the conditions, you might not.
Well,
so it's not in that. I'm just trying to see what the difference is.
I think the difference is that settled status is a different status from what you have under your EU rights, and so you're applying for something different.
Correct.
If you look at the Spanish system in the decree, it's declaratory in the sense that there's a distinction between those who've been more than 5 years and so have a right to permanent residency and those less than 5 years. Life is more complicated for those who've been there for less than 5 years, but the basic reading the decree, the impression that I have is that if you produce your piece of paper that shows that you were registered at a particular point in time, that will allow you to receive what is called the TIE, Tarjeta de Identificación de Extranjero, and that you will get simply on production of the document. So to that extent, it's it's declaratory, but you will have gone through the procedure that Spain has under EU law to have the document. If you've been less than 5 years, you will also have to produce what is the current position under EU law, which is proof of health insurance and a minimum income level or employment or whatever. So it's basically referring back to a level which is the previous existing EU level. The income requirement, for example, has been taken as what is in EU law rather than what the Spanish have for third country nationals arriving afresh in the country, for example.
Okay.
I mean, there's an element of angels dancing on the head of a pin in the discussion between declaratory and constitutive. But just to make this point, your rights under a declaratory system derive from the law rather than from the possession of a piece of paper. And the effect of that is that if you are one of the many hard-to-reach people, and I think Kuba, who gave evidence in the earlier group, made the point very well, there are people who will never be reached through any amount of outreach, which is just obvious. But if in 5 years' time they need something and they need to produce evidence of their status, they won't be told, you haven't got the piece of paper, you didn't get it in time, you're out, you're not having what you want, and you might have to leave the country. They'll be able to get it if they can demonstrate that at the appropriate time they met the requirements. So the piece of paper is less important. It's not all important as it is under a constitutive scheme. You have to have evidence of your status, and those who haven't got it in time will not have the status. That's the difference.
Can I just pursue the point about the Costa Amendment and what do you think of the EU's response that says, well, it's all very difficult, it'll have to be member state by member state, because even outside a withdrawal agreement, even in the event of an no-deal Brexit, we can't really conclude a deal that binds all of us. What do you think of their response?
We're very disappointed, quite frankly.
Yep.
I mean, we mentioned in our paper the process which UK went through after the Costa Amendment. We thought the initial approach to the EU was pretty lukewarm, but we were very much heartened by the letter which Stephen Barclay wrote after our recent meeting with the 3 million and with Mr. Costa, and it was a strong letter which set out the position very clearly. What has to be appreciated, and I think this is a response to Ms. Malhotra's question of the 3 million, is that the reason why a ring-fencing agreement has to be made before Britain leaves the EU is not simply that we need the certainty of knowing what our rights are going to be. That, of course, is an important reason. But there's a legal reason, which is that if the agreement is made under Article 50, while Britain is still a member of the EU, the process is very much more simple. It doesn't require unanimous agreement across all the parliaments, including regional parliaments. And so it's absolutely critical that any default agreement, if I can call it that, on citizens' rights takes place before Britain's exit. And we would strongly encourage the British government to keep up the pressure. We are doing so for our part among the nation states in the EU and with centrally in our lobbying there.
Do you think the EU is being unreasonable in saying, no, we're not going to separate it out in the event of a no-deal Brexit? The question of citizens' rights. Because they could do it if they wanted to, couldn't they?
Frankly, I do.
If the political will was there.
It's about political will.
If the political will was there, and also I wanted to add something to what Jeremy said from the political perspective, and Michel Barnier's letter. Nothing will move on this via the Commission. This will only move if the Council, the EU Council, makes a decision. So the decision on this lies in the EU 27, in each of the EU 27.
But isn't it a bit odd that we spent quite a bit of this evidence session discussing the 27 member states' insistence on reciprocity, and yet the means of ensuring reciprocity all ways round would be to ring-fence an agreement on citizens' rights, but it's the EU member states who don't appear very keen on it? Or is it they haven't noticed that the Commission has said, we can't really do that under Article 50 and it'll have to be down to each member state individually? Why do you think that is?
I think there's a strategic line which has been taken, which is it's withdrawal agreement or nothing. And that includes even citizens' rights. The no mini deals was the original catchphrase, I suppose. What was important, the point that the 3 million made, was that in Barnier's letter in reply to Stephen Barclay's recent letter, we didn't get anything about nothing is agreed till everything is agreed, no mini deals. We would hope that there is still room for that discussion to take place. But as Jane says, it does require pressure from the member states to change their minds about. As you probably know, the Dutch Parliament passed a resolution supporting ring fencing.
Can I just ask you about voting rights? What's the position regarding offers of voting rights to UK citizens remaining in EU member states in the event of no deal?
It varies by country to country.
It varies, yeah.
I mean, some countries allow everybody after a certain period of residence, usually 5 years, EU or non-EU, to vote in local elections. There are treaties which are being signed or agreements which are being signed at the moment between the UK and certain countries. I think Spain's just got one, Luxembourg got one a couple of weeks ago, and Portugal as well. So we will have local voting rights. Obviously we'll lose EP and we won't have national. But obviously we don't. 60% of us don't have general election voting rights here in the UK either.
The Spanish draft agreement with the UK goes a good deal further than most Spanish agreements from a Spanish perspective, because it allows you not just to vote but also to stand for election in local elections. So you can sit on a council, you can be a mayor of a council, as well as just voting. So, and that is something which they have negotiated with the UK, which goes, on my understanding, goes a bit beyond. They have other agreements which do that as well, but not many.
Well, that's certainly welcome. I'd also say it's quite logical, because it'd be a bit odd to give someone the right to vote in an election, but not the right to stand for office.
There is another outlier, of course, which is the Republic of Ireland. The Memorandum of Understanding obviously continues. There is another outlier, obviously, the Memorandum of Understanding between the UK and the Republic of Ireland, which was signed, I think, the 8th of May, does continue the right for UK nationals in Ireland and Irish nationals here to continue to stand and vote in even general elections as well.
Sure. And that stems from the common travel area and agreements that predate our membership of the common market as it then was originally. So that is quite a specific case. Finally, are there, going back to this point, because it's what's come across very clearly from the evidence today is what you may and your members may end up getting depends on the perception of the state in which you're living's view of what the British government is offering to their citizens living here. Are there things that are missing from the British unilateral offer to EU citizens here in the UK in the event of no deal that you would like to see the UK government offering in order to maximise the chance that the member state in which you're living will offer them to you and your fellow British citizens?
Shall I? I'll begin. I mean, I think the biggest point that is often mentioned in our discussions is primary legislation. That would be very helpful, setting out the rights. A second point that would help us is if the UK changed its mind on the system and moved to a declaratory rather than a constitutive system. That would help us. Jeremy, is there anything you want to add?
I think it's quite hard for us to say that these are particular points that have been picked up by member states with us. But I certainly feel that the removal of appeal rights, when the UK was saying this is our no-deal package compared with the deal package, to remove appeal rights was something which sent a very bad signal about the future prospects of EU citizens here.
Okay. Now, just in conclusion, was there anything you had wanted to say that the questions you've had from us haven't given you the chance to express. And once again, thank you very much for the terrific document that you submitted to us. But was there any other points you wanted to add before we bring the session to a close?
The point on the voting rights, just to make that point very clearly, that those of us who have been living in a host country for more than 15 years, and if in that host country there are not voting rights for third country nationals or for British citizens post-Brexit, those people will have no voting rights in anywhere until they can obtain citizenship. And we've already had a discussion about the difficulties of obtaining citizenship and that the conditions differ across the EU 27.
And there were problems, were there not, in those who are able to vote in the UK getting their ballot papers in time? I know from one constituency case that I dealt with in the recent elections. Is that correct?
Yes, and that is a perennial problem in every, I mean, not just in the European elections, but in every national vote. It's a problem that came up in 2015, 16 and 17, and bear in mind only less than 40% of UK citizens abroad could vote in those votes.
Okay. There is also a problem which I think is linked to loss of the right to vote, which is basically that you end up in a situation where you have no elected representatives to which you can address yourself, because even if you write to the person who is the MP for your last known constituency, in other words, where you would be put if the right to vote for life legislation were to be carried forward, basically MPs, if you do not have an address in their constituency or a relative who can provide an address, basically tend to ignore any correspondence. So I have written to the person who would be the person would be my point if things were to progress in that direction, but I've had no reply. And this is very common it's something which our membership stress over and over again, that it's impossible to engage with an elected House of Commons representative, or very, very difficult. And the UK obviously doesn't have a system of a representative for an external constituency or some of the solutions that are provided in other jurisdictions. And I was asked specifically to bring this point up with the committee, that there is a feeling of basically being in a void and not being able to have any response from a democratically elected person anywhere, because you've ended up in that situation. So that's maybe something that members would like to bear as a way to carry things forward in terms of their interaction with the 1.2, 1.5 million UK citizens who are living in Europe.
Well, I hope, concluding on that point, I hope today has helped to fill any void there may be, because you've had the opportunity.
Much.
No, well,
I wasn't
fishing for thanks, but I was just pointing out you're here precisely because this group of members, as the exiting the EU Select Committee, are very keen once again to hear from you about the experience and the worries and concerns of your members and our fellow citizens. That's who we're talking about in the other member states. And I'm confident you will continue to see the concerns you've raised with us reflected in the reports that we produce in an effort to influence those who are making decisions. In this particular case, it's the other 27 member states we're trying to talk to through a megaphone, as well as the government of this country. On behalf of all of the members, can I thank you very much for coming. It's been a really useful and informative session. Order, order.